That might have been the problem. Ms. Hall, can you hear me now?
Good afternoon. I can.
Hey, fantastic. Well, I said only good things about you when it was muted. Ms. Winfrey, you able to hear me?
Good afternoon, Judge. Yes, I can hear you. Thank you.
Good afternoon. Are you handling Mr. Finley's case?
Yes, Judge.
So Mr. Finley is here in court. He and I have been speaking. Unbeknownst to me, you've been unable to hear it because of a technical issue that we just addressed. Thank you, Ms. Patel. Mr. Finley tells us that he intends to retain Beverly Taylor, and he's going to do it today, and he's leaving here to go there to finalize the arrangements. He simply needs a copy of his indictment. So we're going to take care of that, get him of his indictment, and then my office will be following up with Ms. Taylor's office to make sure that she, in fact, is filing that entry. So you have someone to interact with, to get discovery to, et cetera. And if Ms. Taylor indicates that she's not, in fact, going to be representing Mr. Finley, then we will need to make Mr. Finley come back here again, which I'm sure he doesn't want to do. So he'll make it happen. Yes, sir, Mr. Finley. I need you to speak a little louder. Sure. Why don't you type it into your phone? It is 21 S as in Sam, C as in Charlie, 177645. That's your case. So if you go down to the clerk's office, 5th floor of the other building. So the buildings are connected, and you can walk across on the 8th floor. If you go down this hallway, there's a little sky bridge that connects the two buildings. Go across that sky bridge and go down to the 5th floor. That's the clerk's office. Say, I need to get a copy of my indictment. They'll take care of that for you. Any questions? All right, we'll get you another notice to be here if Ms. Taylor says, I'm not taking the case. All right. Ms. Winfrey, anything else you want to share in connection with Mr. Finley's case?
The only question I have, Your Honor, is will this case be set for another plea and arraignment based on this disclosure today?
It depends. If Ms. Taylor is willing to waive arraignment, we'll have her file an entry of appearance and waiver of arraignment. If she chooses not to waive arraignment, then yes, ma'am, we'll get it on another calendar, and Mr. Finley will need to come back here with Ms. Taylor to probably then in court waive arraignment.
Okay. Thank you. That concludes my business. May I be excused?
Yes, ma'am. Mr. Finley, any questions? All right, you think you can find the clerk's office? Well, not across the street. The buildings are actually on the same block, and they're connected by a bridge that is all enclosed. All right, Mr. Franklin's helping everyone today. Follow Mr. Franklin, your tour guide. He's got the Atlanta skyline on his mask. Mr. Matthews, I'm sorry. I was trying to get your attention earlier, not knowing that the system was muted. Can you hear me, Mr. Matthews?
Yes, Your Honor. Good afternoon. How are you today, sir?
And can Mr. Sims, can you hear me? Mr. Matthews, Mr. Sims has 2 cases on today's calendar. There is a case where you are listed as counsel of record, a drug case, and then there's a family violence battery, but it's a felony version. That is his other case. Will you be representing Mr. Sims on both cases?
Yes.
I can't hear you, Mr. Matthews.
Can you hear me, Judge? Can you hear me?
Now I can hear you. Yes, sir.
Okay. Yes, Your Honor. Good afternoon, Judge. I will be representing Mr. Sims on both of these cases.
Okay. Is he waiving arraignment, or does he want to be formally arraigned at this time?
Your Honor, we're going to waive arraignment. If not guilty, we'll be filing motions momentarily on these cases, and I'll be in contact with. I have been in contact with one of the prosecutors, but I'm not certain who the latest prosecutor is. I'll be in contact with that person once I learn who that person is and see where we are to try to get it resolved.
Sounds good. I will make sure Ms. Nelson sends to your office the waiver of arraignment forms for the two cases so that you can get those entered. So they'll be in the record, those waiver of arraignments. Ms. Hall, do you know who is handling position 7 on the calendar, the family violence battery charge?
Good afternoon, Your Honor. This is ADO Com. I'm covering for Ms. Beza. As you know, she's on maternity leave. She'll be back July 12th, so I will be her till July 12th.
Ms. Ocom, it's great to see you.
Yes, Your Honor.
So if Mr. Matthews has questions about position 7, he would talk with you for about a month, and then Ms. Beza will be back and she will be taking over position 7.
Yes, Your Honor.
And Ms. Hall, you have the one position on the add-on.
Yes, Your Honor.
Okay. There you go, Mr. Matthews. Look for an email from Ms. Nelson that has the waiver of arraignment forms. We'll get a scheduling order entered once we get the waiver of arraignment, and we'll go from there.
I don't see his face, but he certainly is impressive here.
Can you say that one more time? You're cutting in and out.
I do apologize. Mr. Simmons, he is present, Your Honor. I did see his face a while back, but I don't see his face at the moment. But he has been on this call.
Yep, I've seen his tile. I just didn't see him. More importantly, you're here. You're taking both his cases, and you've waived arraignment. So you are free to go. And if Mr. Sims can hear me, he's free to go. Otherwise, you can let him know he can go.
Your Honor, may I be excused as well?
Yes, ma'am.
Thank you.
All right. So, Mr. Abate, can we talk about Mr. Hodges' case at this time? I know I'm bouncing around a little bit, but I think we're still working on getting some inmates up. They're all up. Okay, but we'll clear out some of the folks in the courtroom. We've learned about Ms. Hannah's unfortunate passing. I think maybe you had asked for some time to get the notification. I know we got the funeral notice. Mr. Hodge had that, but your office understandably wanted some official paperwork as well. Do you have an update as to Ms. Hannah?
It's been ordered. We're allegedly on the way. As soon as I get it, I'll file an old process or get that, whatever you're on for pertains to Ms. Hannah's case.
Okay. Let me, before we talk about Mr. Hodge, Ms. Bernard, good afternoon.
Good afternoon, Judge McBurney.
It's nice to meet. I think we've met before in passing, but I think this is the formal time of meeting. As I understand it, you are going to serve as our conflict defender until your team has expanded again and you've got a replacement for Ms. Snyder, or are you our permanent replacement?
The first thing you said is correct. I'm
Okay.
subbing.
Okay. Well, Mr. Hodge is represented by your office and had been ably represented by Ms. Snyder.
Correct.
Mr. Hodge, Ms. Snyder has moved on to a different job. She moved on from the conflict defender's office. She worked with you for many years. Ms. Bernard was Ms. Snyder's supervisor and is managing Ms. Snyder's cases while they find a successor attorney. But I want you to know your lawyer is listening and is virtually present while we talk about your case, okay? All right, so Mr. Abate, tell me what is going on the state side of things in terms of these charges against Mr. Hodge and the kind of funny procedural posture they're in.
Like I said, I just want to call Ms. Snyder as a term of
Yeah, that would be why.
So because of that, we're kind of in the same posture. When we left here last time, I had made attempts to speak with Ms. Snyder about a possible resolution that we could find somewhere middle ground between the state's presumed offer and the offer that Ms. Snyder had suggested. Since the last court date, we haven't had an opportunity to have a conversation. It sounds like because Ms. Snyder has moved on to different pastures.
Different pastures.
So, I will be in contact with Ms. Bernard. I didn't know.
Okay. Do you know how to reach Ms. Bernard?
I was an emailer. I took her name down from the Zoom.
Okay,
I can put my email in the chat. Well,
Great.
he won't get that, will he?
he won't, and I won't put it up on the screen, but he'll be able to figure it out. If the DA's office can't figure out how to reach you, they've got bigger issues.
Okay.
So, Mr. Abate has been running point for a while. As you can tell, Ms. Bernard, from the indictment number, this is a very, very old case. It has a rather tortured appellate history as well. Judge Downs did more with the case than I have. Mr. Hodges' co-defendant has passed away. So we are trying to figure out what to do with Mr. Hodge in connection with this case. And
Miss Snyder's note indicates that she was still waiting a ruling on the demurrer for count 2. Count 1 was granted.
so I can turn to that. What Ms. Snyder last said when we learned that Ms. Hannah had passed away was that she and Mr. Abate would talk. Given my understanding of the allegations of this indictment, Ms. Hannah was the more seriously involved defendant. And now that there will be no disposition against her, the thought was, why don't counsel for the state and the defendant, meaning Mr. Hodge, talk about a resolution short of having to finish litigating the demurrer part of things. So my request would be that you and Mr. Abate at least have a conversation. And if you're at loggerheads, let Ms. Nelson know that, and I will add to my list of motions to work on the demurrer as to the second felony murder count.
Okay, thank you, Judge.
Sure. Does that work for you, Mr. Abate?
Yes, Your Honor.
I think what we'll do is we'll put this out about a month so that your busy schedules will be given some time to connect. We don't need to drag Mr. Hodge back here if the answer is we can't agree, so you have to rule on the demurrer. If there's something that will resolve the case, then we should have Mr. Hodge back here, or he can zoom in. You, Ms. Bernard, you and Mr. Hodge can work through that. But if the two of you, the lawyers, figure out, look, we are so far apart, we're not working this out, let Ms. Nelson know. We can take it off the calendar, its next date, and I will work on the other demurrer.
Okay, thank you, Judge.
Thank you.
Yeah,
Thank you.
understood.
Ms. Second, please let Mrs. Snivy excuse.
Yes, sir.
And Your Honor, may I also be excused?
Yes, ma'am.
And it's good to meet you.
Same.
Tomorrow morning, the time is on still 9 o'clock.
Could be. Did I mention I'm in the middle of a civil trial?
That's all double check.
No, the jury's deliberating now, so our schedule for tomorrow is as is. So we do have a calendar tomorrow, and Tyler Thomas is on it. Wow. Okay. I'll have to read the appellate opinion. Or it wasn't an appellate opinion. Was it Judge Downs' opinion? Okay. All right. Is Howard Weintraub still on the case? Bye, Mr. Abate. It's going to be interesting. Okay. Going forward, whoever is speaking in court needs to come up to the podium. Poor Ms. Bernard could not hear anything Mr. Abate had to say. Mr. Hodge, you are free to go. You're still living in the same place. I know you haven't moved, so we'll send a notice to that place for the next time you need to be here. You can come in person like you did, or when you talk with Ms. Bernard, it may be that she and you agree that you're going to dial in like you have before as well, okay? Do you have any questions? Okay, thank you for being here. Mr. Franklin, did you and Ms. Hall get a chance to talk about Mr. Cole?
Yes, sir.
Okay, if you don't mind coming up to the podium. As I understand it, I looked at the virtual PTI. Mr. Cole was to complete a Men Stopping Violence course by about a month ago. Sounds like maybe he did, but unfortunately the form he got says you have completed as opposed to Mr. Cole has completed.
Correct. He attended virtually. He completed the documentation using his girlfriend's email. So the email came back to her particular address. I sent that documentation to Ms. Hall. She's reviewed it. I communicated to her that I also saw the documentation where he registered for the course and completed it on April 9th. So she has, to my understanding, already sent an email to Ms. Nelson with the no approach for the case.
Well, all right. Ms. Hall, were you able to hear Mr. Franklin?
Yes, Your Honor.
Anything you want to add other than I agree with Mr. Franklin?
No. Just.
All right. Great. Thank you for working with him on that.
You're welcome.
So, Mr. Cole, your charges have been dismissed. The term Mr. Franklin used, null pros, is the legal term, but it has the effect of making the charges go away. So if that was the only case you had pending, you're clear and free to go about your business. Okay? So next on the calendar is Mr. Haynes. Before we bring Mr. Haynes out, I guess I need an update, Ms. Hall, from you. I know Mr. Fortis is he was on the call. He still is on the call. Great. So Mr. Haynes is also known as Ian Smith, and he is on our calendar for a revocation in a very old case. The petition says he has 10 entering auto charges. I don't know if it's 10. I will note that he has 6 unindicted CP cases, all of which appear to be entering auto. Ms. Hall, what's the latest from the state side as to Mr. Haynes, aka Mr. Smith?
Your Honor, we have gotten most of the discovery in the 6 open CP cases, but the Intake Department says they need about 45 more days to have those cases ready for grand jury.
Okay. Mr. Fortis, I know we've had a couple pauses on this one because you were interested in seeing what's going to happen with these unindicted charges. And Mr. Haynes is obviously stuck in custody while we do that. But we can also agree on a date where we would have a revocation hearing and the state could seek to prove up one or more of these many entering auto allegations. Where are you thinking this is going right now?
Well, Judge, can you hear me okay?
I can.
Okay, great. What I would like to see happen and what we've been working on, and I've been working pretty close with the family on this. This is a classic substance abuse problem with drugs. His mom is aware of it. We have been in contact with Hope House, and I've been in contact with the director over there. And I know that he petitioned the jail to go out and interview him to see if there was going to be some space available and what his findings were, if he felt like this would be a good fit. That was where it was probably a couple of months ago. I haven't heard back from him from the Hope House, but that's pretty much the posture, we're kind of looking at is some, in confinement rehabilitation. This drug issues, from my conversations with his family, has been going on for quite a long time, and they would love to see him get some help. And as soon as I get all those particulars together, I was going to speak to the state. So I think a revocation hearing at this point would be premature, when we may be able to wrap everything out. And I say maybe, I don't know what the state's posture would be, but I haven't been able to put everything together to do the presentation of it yet. So what I would suggest is maybe 60 days out. That'll certainly give me ample enough time to come to a conclusion on that. Also probably get all the discovery, and then probably wrap everything up together would be my hope.
Okay, that sounds like a possible plan. Officer Woodward, are you with DCS?
Yes, Your Honor.
How are you?
I'm great. How are you?
I'm well. Are you filling in for Ms. Crawford today?
I am.
Thank you for doing that. Do you know how much time remains on probation for Mr. Haynes in this 14 SC case?
Yes, he currently has 3 years and 22 days left on probation.
Okay, so we're not at risk of this running out. We've got 3 years still to work through.
Correct.
Okay. Ms. Hall, it sounds like your office wants a little more time to get its arms around all the discovery for purposes of indicting or accusing the cases. Mr. Fortis is asking for a little more time to work on a possible resolution that seems to be aligned. Do you have anything you wanted to add, Ms. Hall?
No, Your Honor, that I have no objection or anything to a reset and holding off on the revocation for now.
Mr. Fortis, 2 things. One, is there a reason that you are not considering drug court for Mr. Do you call him Mr. Haynes or Mr. Smith?
Call him Mr. Smith.
Okay, I'll do the same. Is there a reason why you are not considering drug court for Mr. Smith and thinking about Hope House instead? And they're both great programs. I'm just curious, one we've got a whole lot more control over than the other.
No particular reason. It was just one that, I've worked with in the past. It had good results. Drug court has good results too. If the court or the DA's office would consider drug court, certainly we would consider that. However, I think that his family believes, and I'm not sure if the drug court has, the confinement piece to it, which is pretty much what the family wants. They think that
inpatient treatment
beneficial. Yeah,
okay.
The inpatient treatment part of
Got
it is really what they're after.
Okay.
And I think that based on what I know now that I didn't know in our first meeting in court, I think that would probably be more beneficial to what's going on.
Okay. Well, you can explore that with your client's family as well as with Ms. Hall. I'm fine if treatment is what he needs. It will need to be a fairly robust program and not hey, he's going to go to a couple of NA meetings here or there, given what we're looking at. Other question, more immediate. Mr. Smith is here, meaning he's back in lockup. Do you want him brought out, Mr. Fortis, so I can let him know what's going on, or do you prefer to communicate that to him in your own way?
Well, I think the fact that he's been brought down, if the court, I'm not trying to waste everyone's time or the court's time, but if you could bring him out and just generally tell him what's going on, so he's just not turned away, and not come out.
Okay, we'll bring him out. He can just be brought right to the door right there. Thanks.
That's fine.
Who is handling Mr. Kojo's case? Ms. Primovic had been doing it for what? You?
Handling it is a unusual term. I came over here to kind of figure out what the state was in terms of its status on the news.
Okay, but for someone to be able to talk, you, okay, great. It was nice of you to send me the little instant message. You have 2 minutes before you turn off. Hey, Mr. Smith. I'm well. I'm Judge McBurney. We've maybe seen each other over Zoom a few times. He can hear you. I don't know if he can see you actually on one of the screens. Your attorney, Mr. Fortis, has dialed in, and the prosecutor, Ms. Hall, has dialed in. I just wanted to give you an update on what's happening. The state is preparing to present, you have a bunch of unindicted charges, which you know about. State's preparing to present those to the grand jury. Mr. Fortis, your lawyer, has been working with your family about lining up some options for you, short of going to prison, getting treatment, help, things like that. The state has asked for a little more time, so they get all their items in a row. Mr. Fortis has said he needs a little more time to get a more persuasive and comprehensive package of treatment for you that he could present as a way to resolve things. Just so I know you recall, you've got an old robbery case that you're on probation for. That's our connection. It was Judge Downs's case. I have her cases now. And you got all these new entering auto allegations, but they haven't been indicted yet. But it's those allegations that are the basis to maybe revoke your probation. And what Mr. Fortas wants to do is get everything into one setting so that you're not just dealing with a revocation, but you're also dealing with the new charges. The state is trying to get those new charges formally indicted. So we're going to get you back here either virtually or in person in a bit. That should give Mr. Fortas time to work on some treatment ideas, and it'll give the state time to get these charges formalized. Does that make sense? It will. Well, the next time we talk will be in front of me. These new cases that get indicted will be randomly assigned to a judge. It could be me, but it could be one of 14 other judges as well. And then you and Mr. Fortas can decide, do we want to just pull the revocation piece over to go with the new cases? And that'll be a decision you and he make based on who that other judge is. It'll be in this building. It just may not be in front of me. It'll be with Mr. Fortas 100%. Okay? Just wanted to give you that update. All right, be safe.
Thank you, Judge. I really appreciate you doing that for me. Thank you.
Not a problem. Next time, please do not dial into Zoom while you're driving.
Okay. I got it. I was just running late, but I understand.
You're always running late. All right, I'll see you.
Bye.
All right, next on the calendar is Mr. Kojo, and I will bring him out, but only after we've figured out what we're doing if someone wants Mr. Kojo to come out. So he has, like Mr. Smith, an unindicted situation, and it's been unindicted for a while.
Correct.
Okay.
And he's also currently being held on without a bond on the probation warrant as well. So
right.
He's held on two things.
Right. And that is, if you will, our connection to it. And it's actually one that it was a McBurney case, and so it should be a Carnesale case, but Mr. Kojo's situation is real complicated, and I asked Judge Carnesale if I could just keep it, and she said that's fine. So that's my connection to it. So tell me what you know is going on, or should we get an update from Ms. Hall?
I can tell you what Ms. Hall said, but maybe it's best to hear from her.
Hey, Ms. Hall, what's happening with Mr. Kojo's unindicted case, which I think is a fairly similar set of allegations to the old case. Is that correct?
Yes, Your Honor.
Okay. Does it involve a family member again? This old case, his mother was the victim.
No. I think on the new case, I looked at it a couple weeks ago, but when I looked at it, I believe it was not a family member.
Okay.
It was an actual DV case, because I reached out to DV to see if they had been trying to get it indicted or not. I hadn't heard back because I was confused on who was taking over for Miss Asia after Miss Hilton was in.
Yeah.
But I did reach out to the intake to see what their update is, because it looks like in our system we have all of the discovery and everything in plan or in place in the order in which they want to do it. So when I reached out to intake, they said they need about 3 weeks for the case to be presented. It looks like this is an officer issue. The case has the officer has been subpoenaed more than once for grand jury. And so I don't know. So I don't want to say whether he's on leave or anything like that. I wanted to actually reach out to the actual person who wrote up the indictments, who was reaching out to the officer, because he could have been on leave, but it is a situation of getting the officer in for grand jury.
Okay. Thank you for that update. These new charges, I can't see who the purported victim is, but they don't. You're saying you think it's a DV case?
I think so, Your Honor. I can pull it up really quick.
If I may, Your Honor,
please.
My recollection, and subject to being incorrect, he had a visitor at his mother's home.
Okay.
And there was some incident between
the visitor and Mr. Kojo.
That's my understanding.
Okay.
I don't think I'm conflating it with another case. I believe that's his case. So.
I know he had been living at his mother's place. And
correct.
Our history was back to just doing okay on probation, not at this level, but taking medication, meeting with the folks who were part of the conditions of sort of like a ACT team.
Services.
Yeah, exactly. So it doesn't sound like the state needs much more time, but I know Mr. Kojo's been in custody for a long time.
400 some odd.
Yeah. Let me ask our new friend, Officer Woodward. Officer Woodward, how much time remains on Mr. Kojo's 15 SC case?
He currently has 7 years, 10 months, and 12 days left.
Okay, thank you. Yes, Ms. Hall?
I'm sorry, Your Honor, I didn't mean to interrupt. Go ahead.
I was just going to ask Mr. Franklin what he thought we ought to do at this juncture. In some ways, it's similar to Mr. Smith. We could have a revocation hearing. If the state is then going to proceed with an indictment, Mr. Kojo sort of has to deal with the same charges twice rather than once. What is very different between Mr. Smith and Mr. Kojo is the duration of Mr. Kojo's stay at the jail. It's more than double. So, but you are pinch hitting right now.
Yeah. So I think in light of the history of kind of what the grand jury's been going through for the past year, I don't think a reset for 3 weeks is unreasonable. I would just go ahead and add a buffer and just say, can we reset for a month? If it's not indicted at that point in time, I would like the ability to address bond.
Yep.
And I'm not sure if we would be able to address a bond on a warrant, but if not, then
I think I'd have to set aside the warrant because the state, you've had this happen before. It could be that I indicate that we need to have a revocation hearing and the state could say, we're not going to go forward with these charges at this time. And then I would dismiss the warrant and then Mr. Kojo would be back on probation. I don't know that he has a bond for the CP case. That's the
recollection that he does not.
So that would also make what we do on the probation side kind of moot. Yeah, he was denied bond in October of last year. So he's due for another bond hearing.
Yes, sir.
But why don't we do the reset like everyone's talking about? Ideally, just for tracking purposes, the state brings forward these charges that they intend to, and then we can figure out the best way to coordinate revocation and new charges.
Yes, sir.
Okay. Have you spoken with Mr. Kojo?
Not in some time.
Okay.
I intend to speaking with him today just to give him an update of.
Okay, why don't you do that? And then if you think it would be helpful for me to do that as well, I will gladly have him come out here and he and I can talk.
Yes, sir.
But you can let me know what you think will work best there.
Sir.
Ms. Harlan. Yes, ma'am.
I was just going to interrupt to say I did figure out or remember the issues with this case. So the victim, there are two victims. The initial victim would be a DV case, but then there's an Uber driver who was waiting on the victim and was also shot at in this case. So my concern was, or not concern, but I needed to figure out whether this was going to be a case that stayed with me because it was half DV and not. That's why I reached out to the domestic violence department. So I just need to figure out, it doesn't matter who handles the case, but those are the victims. There's an Uber driver and then an actual intimate partner as the person who went into the home and the dispute happened between that person.
Yeah, I'm looking at the affidavit. It'll be interesting to see. Ivy is all that we have for the non-Uber victim. If Ivy is a long-term acquaintance or a one-time acquaintance, based on sort of what the allegations look like. So I don't know that it would be DV, but it's clearly it's serious allegations. But thank you for flagging that. I see that now. Mr. Franklin's going to talk to Mr. Kojo, and if Mr. Kojo understands the situation, then we'll get him back here soon. Otherwise, if I need to chat with him, I will do that. All right. Thank you, Mr. Franklin. So I think all we have left are Mr. Tatum and Mr. Carr. If it's all right with you, Ms. Patel, we'll do Carr first, and then we'll do Tatum. Have you had a chance to talk to Tatum yet? Okay, before we do any of that though, Deputy Gordon, could you check on our jurors to see if we've got them all? We're missing one? Interesting. Okay, well, when you check again, let me know when all 14, when did you last check? Okay, check again, because they should all be back now. I just want to be able to take care of that. While we're doing that, do you want to speak with Mr. Tatum? Can we support that? Do you have enough folks? Great.
I'll wait on.
Yeah, so the jurors are in 8F. They have to have a whole courtroom, so they spread out. So they're down in 8F. How long do you need to chat, you and Mr. Rao and I? Does it need to be on the record? Is it a?
Doesn't need to be on the record.
Okay.
15 minutes.
Oh, 15 minutes. Okay. All right. We're just trying to use this downtime. Okay.
You may have questions, but.
I'm going to have questions if we're not going out next Monday. So it may be 15 minutes.
We have questions.
Okay. Is Goolsby going to go out? One step at a time?
There's a lot of explanation. So in light of the fact that I had votes and I was expecting when it matured to go, that's where the majority of my energy is going.
Okay.
And
We'll talk.
so no follow-up, Mr. Rouse. Some other things.
Hey, you take a break? Great. We have everyone. Okay. Can you please call the red number? That's our court reporter, and ask her to come. Oh, she's right outside? Great. All right. Mr. Kendall, I'm going to have Deputy Gordon and Ms. Tucker, need you both. I'm going to have Deputy Gordon bring our two alternates in here, and on the record, I'll tell them they're the alternates and how it's going to work for them. And then they're going to go into the jury room. Then we can figure out, do we have all the right exhibits, et cetera. So if you would please, Deputy Gordon, get juror last name McCoy. No, sorry. Last name Kwasnick and last name Bowl, B-O-L. Kwasnick and Bowl. What case are you here for, sir? Sir? How are you? What case are you here for, Mr. Kojo?
Yes, sir.
You're his father.
I'm his father, yeah.
How are you?
Fine, thank you.
I thought I recognized you. I haven't seen you in a long time. Are you in good health?
Right. I'm fine, sir.
Good.
Thank you for helping my son.
We are doing what we can. It's a complicated situation. And Mr. Rao, you are here to talk about Bonventura. Okay. And are you both here for the Tatum matter? You are. Oh, all right. I think we've seen you in person or on TV? On TV. Okay. So did you hear? Great. You can bring him in. You two can sit or stand wherever you want to be, just front row, please. Sorry for the sort of disjointed appearance. We're in the middle of some criminal matters. But Mr. Kwasnick and Ms. Bull, you are our alternate jurors. So you are our protection and backup should, during the course of the many days, we have lost a juror because someone was ill or something came up. You are going to remain here today as long as your colleagues are deliberating. If they don't finish today, we can talk about how quickly you could get down here tomorrow should we lose a juror. But you could probably remain at home or go to work as long as you could get here within 30, 40 minutes. If you got that call saying, uh-oh, we need one or both of you because. But for the rest of today, I'm going to put you in our normal jury room. That's big enough that you should be able to socially distance. If you're not comfortable in that space, let me know and we can get 2 different spaces. But it's where all the jurors would have been sitting, and you'll see why we put you all in 8F instead. You can keep your electronic devices. You guys can interact. Just don't talk about the case. You need to remain in that protective bubble of the only thing you know about the case is everything that was shared in here and not anything that might be online. Because at any point, either of you or both of you could be pressed into service as deliberating jurors. So keep your stuff. I promise we won't forget about you. If the other jurors reach a verdict at some point today, we'll let you know that. You can come out here. You just won't be with them while they're deliberating. Any questions about that, Mr. Kwasnick? Ms. Bull? All right, so if you have all your belongings, go on into the much more comfortable space of the jury room. Actually, Deputy Gordon will show you where it is so you don't have to navigate. I think there are a few things in the way. There are restrooms in the jury room, so you don't need to worry about that. They're your personal restrooms. And then we'll just make sure someone checks in on you every once in a while, okay? Thank you so much. All right, we're still on the record. Mr. Kendall, have you had a chance to look through plaintiff's exhibits and are you prepared to send those to the jury?
We are going through those documents. They are still redacting them. But they've given us a stack and we're checking all of those off right now.
Okay.
And we've given them ours and I think they are good with ours.
I'm going to ask just that. Ms. Tucker, have you had a chance to review defendants' exhibits?
Yes.
And do they satisfy your concerns about what was admitted, what needs to be redacted? Okay. Then let me know both sides when you have completed your review of everything. Then we'll get Deputy Gordon to take all the exhibits to 8F along with the verdict form and the jury charge, and he will trade those things for all the jurors' electronic devices. So you're going to need like a Santa bag or something to make the trip back and forth. But for now, we can leave the jurors in 8F alone while the parties finalize what they promised would be a quick process. All right.
I'd like to give the court back 281. This is the one we marked, not going back to the jury. I don't know where the court wants to put the exhibits that were marked, but not going back.
So that'll be a conversation you can have off the record with Madam Court Reporter, because I won't be keeping them. I mean, they'll be part of the record, but the court reporter's record. All right, Ms. O'Neill, anything else before we go off the record?
No, Your Honor.
Mr. Kendall?
No, sir.
All right, thank you. So, Mr. Cruz, are you ready for Mr. Carr?
Yes, sir.
Great. If you would come on up to the podium, we'll have Mr. Carr come out to the podium. Ms. Hall, are you handling the Carr matter? Great. Ms. Patel, did you have enough time with Mr. Tatum?
Yes, Your Honor.
And is it a plea?
Yes.
Okay. All right. You ready, Ms. Rivers? Okay. This is case 21 SC 177390. It's State versus Brian Carr. Mr. Carr is present in court along with his attorney, Mr. Cruz. Ms. Hall, the prosecutor, is appearing remotely. That screen may show Ms. Hall. Insofar as you want to see her, you will be able to hear her. Good afternoon, Mr. Carr.
Good afternoon, sir.
Mr. Carr, all we're going to talk about today is bond. Mr. Cruz has filed a motion seeking reconsideration of bond. You appeared in magistrate court in October of last year and were denied bond. And Mr. Cruz is going to share with me today why I should review that decision and make a different one. So I'll hear from Mr. Cruz, then I'll hear from Ms. Hall. It may be that there are, whether it is, find the name, Mr. Owens or family members of Mr. Owens who are participating in this conversation, and they may have something to say about it in terms of concerns about bond. Although from what I've read in Mr. Cruz's motion, I'd be surprised if Mr. Owens has dialed in. Mr. Owens, why don't you, Mr. Cruz, why don't you get us started?
Yes, sir. And thank you, Your Honor. I want to say thank you to Ms. Hall. I want to say thank you to Mr. Carr. We have several witnesses on the line in support of Mr. Carr's bond. In consideration of the court's calendar and understanding that a jury is currently deliberating, if the Honorable Court will allow, and if Ms. Hall does not have any objections, I will proffer the testimony of those witnesses or what I would expect for them to say.
Okay.
Now, Your Honor, we are aware that Mr. Carr is presumed innocent at this point. But due to the nature of the crimes that we're dealing with, there are some facts that Mr. Carr and I would like to share with the Honorable Court. I believe since between August 12th, since August 12th of 2020, Mr. Carr has been incarcerated in the Fulton County Jail for a period, I believe, of 305 days. My math isn't incorrect. We've been indicted on 2 counts of aggravated assault, 2 counts of possession of a firearm during the commission of a felony, 1 count of aggravated battery, 1 count of criminal damage to property in the first degree, and 1 count of possession of a firearm by a convicted felon. The indictment stems from the August 9th, 2020 shooting of Mr. Quentin Owens. Mr. Owens at that time was sitting with a young lady by the name of Miss Michaela Blake. And I may mispronounce the first name, but I believe it was Miss Michaela Blake. At the time of the shooting, just a short rendition of the facts, Mr. Owens was in the passenger seat arguing with Miss Blake, who was in the driver's seat of her white BMW truck. At the time of the altercation, they pull over to the side of the road. They continue the argument. A vehicle pulls up. Shots are fired from that vehicle. Mr. Owens jumps out the window, runs into the gas station. Officers come. And if I misstate anything, Ms. Hall will correct me. But from my understanding of police reports, officers come at the scene. They speak with Mr. Owens. Mr. Owens states that an individual by the name of Twin shot him. And this is not a name that Mr. Carr currently goes by, or nor has he ever gone by that name. Mr. Owens goes to the hospital. Surgery is required for Mr. Owens. Officers speak with Ms. Michaela Blake. Ms. Blake states that she didn't see anything. She didn't see the vehicle. She didn't see the shooter because everything happened so suddenly. On August 12th, if my data is correct, on August 11th, officers go to the hospital to speak with Mr. Owens to get a version of events from him. At that time, Mr. Owens is undergoing surgery or has just completed surgery, so he wasn't lucid. August 12th, officers speak with him again. However, before the August 12th meeting with Mr. Owens, officers review video surveillance footage from around the area. From the video surveillance,
The area would be, there's a gas station. You said that Mr. Owens had run into the convenience mart after the shooting. Is it a gas station or where?
This is a gas station,
Okay.
correct. The shooting happens behind the gas station.
Okay.
So there's cameras in the area. I'm not 100% sure yet, but and this is from the police report. There are cameras in the area where officers state that they see a gray colored vehicle. And with this gray colored vehicle, they see it drive by and they see Mr. Owens at that point jump out of the car and run towards the gas station. The way Mr. Carr was identified from the video is that one of the officers stated in his report that the car resembled a Chevy Malibu and it had a distinct dent in the vehicle. At this point, he writes in the police report that he noticed a distinct dent. On the 12th, he goes to speak with Mr. Owens. At that point, Mr. Owens changes, or at least gives a new rendition of who shot him. He says an individual by the name of Drizzle.
Drizzle?
Drizzle, yes, sir. An individual by the name of Drizzle shot him. Because at this point, Your Honor, as you know, we haven't had opportunity to speak with Mr. Owens or speak with officers. We don't know if Mr. Carr is identified on the basis of someone who potentially drives a gray Malibu vehicle, and Mr. Owens was simply stating, hey, this is who I know who drives that type of car. However, at the time of that discussion, Mr. Owens provides a location of where he could find this vehicle. And this was on Cleveland Avenue. He said you could find the vehicle. And I don't know how to get to the conversation of the vehicle, but he pretty much said you can find the vehicle and you can find Drizzle on Cleveland Avenue. The officer goes to Cleveland Avenue. He sees a vehicle, a gray in color Malibu. You know, I'm at this time we're able to compare the video vehicle versus the vehicle the officer saw. However, he runs the tag on the vehicle. The vehicle comes back to Mr. Carr. At that time, he does not conduct the traffic stop. He says that Mr. Carr's vehicle got out of sight pretty quickly, but he does not perform a traffic stop. Mr. Carr is arrested, from what I understand from the police report. We're not a second, excuse me. Oh, I'm sorry, I'm saying this wrong. Skip the part. So based on the driver's license photo that was obtained from running the tag, they go back to Mr. Quentin Owens at the hospital. And again, all this is from the police report. Ms. Hall, please correct me if I state anything wrong. They go back to the hospital with that photo. They conduct a 6-person lineup, and Mr. Owens identifies Mr. Carr as the individual that shot him. And based on that, warrants were taken out.
Does your client ever go by the nickname Drizzle?
When I asked, no.
Okay.
He does not.
Neither Twin nor Drizzle.
Twin nor Drizzle. Is
okay.
That correct?
That's correct.
The issue that we're having, Your Honor, that we've had for a period of time, and I've spoken to Ms. Hall about it several weeks, well, I believe it was about 2 weeks ago we spoke about it. We've tried extensively to speak with Mr. Owens just to understand the identification. Is this something that, you know, I saw this person? Is this an issue of officers told me this is the car they saw in the area? I know a person who drives this type of car. Unfortunately, despite diligent efforts of our own private investigator, we have not been able to locate Mr. Owens. Now, our office personally, outside of the personal investigator, we used the information that we had on the court's documents, police reports, as far as Mr. Owens' address. I spoke with the homeowner at that address via telephone. She advised that she had not at that time, me and her spoke. She did not have any contact with Mr. Owens, and the last she saw him was last year summer. Okay. I spoke to Ms. Hall about it, and if anything has changed, Ms. Hall stated that she spoke to the victim in February, I believe, Mr. Owens in February, but she stated
February as in of this year, 2021.
I believe so. And Ms.
Okay.
Hall, if that's incorrect, please.
You'll get a chance to weigh in.
Yes, sir. But she spoke to him this year in February. However, the last 3 attempts have been unsuccessful. Before Ms. Hall was on the case, I spoke with 2 other individuals in the district attorney's office. Both of those individuals were unsuccessful in getting in contact with Mr. Owens. We have not attempted to reach out to Ms. Blake because Ms. Blake simply stated to police that she didn't know what occurred.
Okay.
As far as Mr. Carr, and excuse me, those are the facts that I wanted the honorable court to have.
Okay.
Excuse me. As far as Mr. Carr is 32 years old, barring that he hasn't had a birthday recently. 32? Okay. He's 32 years old. He has a high school diploma. He has successfully completed high school, Your Honor. He's extremely hardworking and a family-oriented gentleman. He's extremely intelligent, well thought out, and well-spoken. He was born and raised in the Vaughn City area of Atlanta, Georgia. He currently remains and lives in Atlanta, Georgia. He worked, or before he was in custody, he worked at the State Farm Arena. During the time of the events that transpired around this case, State Farm furloughed employees for the purpose of them closing down due to COVID-19. However, his family has assured me that if he is granted a bond by the honorable court, he would be employed with State Farm as one of his family members. They're a manager at the arena. So he would be working with that individual.
Where would Mr. Carr live if he made bond? At the Magnolia Street address?
Well, it's up to the honorable court. So he could stay with his wife, the honorable court allows, or his mother. So he has 2 addresses that he could stay. I don't have those addresses here. I have it in the file. The honorable court would like for me to look.
So the Magnolia Street address that's in the system, is that your mother's address or your wife's address?
My mother's.
Mom's? Okay. How long have you been married?
3 years.
You have kids?
Yes, sir.
How many kids?
With my wife, I have 1, and all together I have 4.
Okay. And your wife lives near Magnolia Street or somewhere else?
Somewhere else.
In the Atlanta area?
Where is that? She just recently moved to a little bit past Six Flags.
Okay.
And she's on the call, Your Honor, if you wanted to ask her. It's Miss Erica Carr. Is the screen name Erica?
Okay, I see that. So Ms. Carr is out towards Douglasville.
Correct.
Okay. So what kind of work would you do? State Farm Arena is back in action. They had 1 zillion people at the Hawks game.
Yeah, I kind of saw some of the game yesterday.
Yeah, that was a better one to watch than the one before. But what would you do for employment to take care of your family?
I'll be back at State Farm Arena, and I also have another job lined up as a roofing company that I used to work with.
Okay. What's the roofing company called?
I don't know. He just started up the new company.
Okay.
But I was with Nations at first.
All right. Mr. Cruz, other things, or you've covered what you want to cover?
Yes, sir. Just a few other things.
Okay.
And I'll make it quick. So Mr. Carr does not have a passport. There will not be any firearms in the home. While he's been in custody, there are no DRs. And there are currently no holds on Mr. Carr. As far as his criminal history, of course, Mr. Carr back in 2008 was convicted of a DUI. And these events happened while Mr. Carr was in the military. So in 2008, he was convicted of a DUI. 2009, he was convicted of possession of a controlled substance. And also in 2009, and these were charges that were together within the same charging document. He was also convicted of false statements From the criminal background history report I have, there's no disposition on those cases, but from what I understand from Ms. Hall and talking to previous counsel, there are dispositions on those cases. So just to be safe and not to misstate anything to the court, I err on the side of caution.
Okay, well, it sounds like there was some court martial that was the equivalent of a felony because it's what the state has alleged.
Correct.
In the possession of a firearm by convicted felon.
Correct.
Okay, got it. Keep going.
As far as in Georgia, the only thing that he has is driving, acquiring a license plate for the purpose of concealing information on a motor vehicle. The issue with that is his stepfather, who was also on the call, explained that the whole issue surrounding those charges were based on his actions and not Mr. Carr's actions. There's no disposition on that case, either, Your Honor, from our records.
Mr. Carr, what branch of the military were you in?
Marines
For how long?
for 3 years
Were you out on the West Coast or were you in?
at Camp Council.
And then because of the court martial, you got discharged?
Yes, sir.
And the court martial was for this drugs and false statement thing?
Sir.
What kind of drugs?
Marijuana.
Okay. So I guess it was 09. I was going to say in California, that's not even a crime, but in 09, it probably was.
We was in Iraq at the time.
Wow. Okay. How long were you overseas?
7 months.
Okay. We're going to pause for just a second, and I'm going to shift to the civil matter. Could we take 90% of the exhibits along with the verdict form and the jury charge to the jurors and let them get started? Or is either side concerned that what hasn't been blessed is so critical it would be unduly emphasized if it came in 5 minutes later? I'm just anxious to get them going.
I don't think, we're good with saying what we got out.
Okay, there's still a little more work to be done, but we could empower Deputy Gordon to now do this handoff.
Yes.
Okay, do we need to finish with Mr. Carr first? Okay, we'll finish with Mr. Carr, and then let's get the jurors working. All right, so you were with the Marines, you went overseas for 7 months. That's where this false statements and marijuana thing actually happened, was in Iraq. But it gets dealt with, does it get dealt with in Iraq? And you get sent home?
I got court-martialed in Iraq, but when I came back home to California, that's when I did a year and a half in the brig, and they let me out.
Okay.
Of the Marines.
Was it a lot of marijuana?
No.
But you do a year and a half, that's just what happens if it's in the Marines.
Yes, sir.
Okay. All right. Anything else?
Yes, sir.
Cruz.
The Ayala factors. And Your Honor, we have here, I hope they're still here. We have several witnesses, and I'll proffer their testimony. But I believe we have here Ms. Sandra Link. She is on the call with Mr. Carr's mother. And I'm trying to see if I see Ms. Riley's name on here.
Anthony Brown.
Okay, they're together. Okay. And if you could turn your screens on for me, if you're here for Mr. Anthony Carr, just so the honorable court could see you. Mr. Brown, Mr. Kelly, Mrs. Carr, anyone here in support of Mr. Brown, Mr. Grogan?
There's Mr. Brown.
Okay. And Mr. Brown, is Ms. Link and Ms. Riley with you, or are they on a separate on a separate device?
They are actually on a separate device. Let me see if I can get them real quick.
Okay.
Mr. Brown, before you do that, tell me your connection to Mr. Carr.
He is my stepson.
Okay. And would he be staying with you on Magnolia if he got out?
You know what? My wife and I really haven't talked about that as of yet. Is he staying with us?
I mean, if it's fine, he can stay with us. That way I can know that he's good and I know he's good and he's supervised. He's no problem, but I'm willing to take all the responsibility.
Okay, I wasn't requiring that. I was just trying to understand. It sounded like Mr. Carr had two options. He could be with his wife out towards Douglasville, or he could be with you and Mr. Brown on Magnolia. But of course, he cannot be there if the answer is that house is full or it's not safe for him or whatever.
Which house?
Yours.
Mine's is safe.
Okay, I'm glad to hear that. Do you have concerns about the address out near Douglasville?
No.
Okay. All right. Well, I appreciate you all being there.
And
Who else?
Just shortly to go through the factors, just to put it on the record. Charlie,
Okay.
Please forgive me. We have Miss Sandra Link on the line, and that's SANDRALINK. She was born and raised in Lakeland, Florida. She moved from Florida in Ohio. She was staying in Florida in Ohio. She moved here in Atlanta in 2007. She has never been convicted of a crime. She's retired from Piper Aircraft Company. She will testify to all the Ayala factors favorable for Mr. Carr. He will not flee the jurisdiction if granted a bond. He will not obstruct the administration of justice. He will not intimidate any witnesses. He will not be a danger to any property in the community. He will not be a danger to any person in the community. We also, as the Honorable Court, had an opportunity to speak with Mr. Anthony Brown, who is Mr. Carr's stepfather. He is from the city of Atlanta. He's from Vine City, born and raised, and currently resides in the Vine City area. He is currently the floor supervisor in the Premium Club at State Farm Arena. This is where Mr. Carr would work if given the opportunity. He has been there for 3 years. Previously at Boston Market for 15 years. He will answer all the Ayala factors favorably for Mr. Carr, as I just announced for Ms. Link. As he stated, as well as his mother, Ms. Pamela Riley, have stated, they are willing to allow, they are aware of Mr. Carr's charges. They are willing to sign his bond, and they are willing to put their wealth up for Mr. Carr. And I did explain to them, the Honorable Court can set conditions that if Mr. Carr fails to abide by those conditions, they would forfeit their wealth. And they said that we're willing to forfeit and bet our wealth on Mr. Carr.
Is that true, Mr. Brown?
Yes, sir.
Okay.
I have Mr. Corey Kelly on the line. He's Mr. Carr's oldest brother. He is 36 years old. He's born and raised in Atlanta, Georgia. He's also aware of the seriousness of Mr. Carr's charges. He's worked in construction for the past 10 years. He currently works with Berkeley Foundation Company. He has been with them for 5 years, Your Honor. He is the father of 3 children. He stated that he is also willing to sign Mr. Carr's bond and put his wealth on the line for Mr. Carr. And he is aware that if Mr. Carr fails to abide by the conditions of bond, he would lose as well. And he would also answer favorably to all the Ayala factors, the same way as I stated for Ms. Link, as well as Mr. Anthony Brown. We also have Mr. Joshua Grogan on the line in support of bond for Mr. Brian Carr. He's Mr. Carr's best friend. He's born and raised in the Atlanta area. He currently stays in Smyrna, Georgia. Mr. Grogan is 32 years old. He's been employed for the past 7 years in the food industry. He will answer the Ayala factors in the exact same way as the previous individuals that I've stated, Mr. Kelly, as well as Ms. Link, and Mr. Brown. Mr. Grogan also states that he will personally assure that Mr. Carr returns to court when it is time for him to return to court. And he also stated that he is willing to put forth his wealth on behalf of his best friend, Mr. Carr. We also have Miss Erica Carr on the line, who is Mr. Carr's wife. They have a child together. However, as a family, Mr. Carr said that you have 4 children together. She is definitely on the call, Your Honor. She's born and raised in Atlanta, Georgia. She's a high school graduate. She's employed as a club and catering manager. She has been in this position for 5 years. They currently live, when he's not in custody, Mr. Carr and her, they were, before moving to this Douglasville address, is it Douglasville? Is that correct? They were staying in Atlanta, Georgia together. And she could provide the address if the Honorable Court wants that address for the Honorable Court's consideration. There will be no firearms in the home. They have been married for 3 years. She is okay for house arrest. She has never been convicted of a crime. She explained to me that she is okay with the ankle monitor in the home if that becomes necessary. She is also willing to put up her wealth for Mr. Carr's bond. And she explicitly stated that she is willing to lose everything if Mr. Carr fails to abide by her bond condition. I quote, I'm willing to risk it on Mr. Carr. She would testify the same way in regards to the Ayala factors in favor of Mr. Carr's bond. If bail is granted, she did state that she would like Mr. Carr to reside with her and the children, as there are 3 children in the home. And lastly, Your Honor, I have Ms. Pamela Riley. That's the young lady you spoke with, Mr. Carr's mother. She's, of course, known Mr. Carr his entire life. She's a state of Georgia employee. She's been with the state of Georgia for 32 years. Born and raised in Atlanta. She was also raised in the Vaughn City area, and she currently resides in the, excuse me, I misstated. She resides in the Vaughn City area, but she was born and raised in Atlanta. She is a high school graduate. She has never been convicted of a crime. She is aware of Mr. Carr's charges and the seriousness of these charges. She is willing to forfeit her wealth if it becomes necessary and put up her wealth for Mr. Carr's bond. And she is aware that she could lose her wealth if Mr. Carr does not abide by the bond conditions if the Honorable Court will give Mr. Carr a bond. Your Honor, I want to thank you for your time. Mr. Carr and I, we want to thank the Honorable Court for your time. And that is everything that we have as far as the witnesses. After Ms. Hall, we would only ask to be heard in closing.
Okay, well, that was very thorough. What we're going to do is pause briefly. I'm going to ask the deputies to take Mr. Carr back to lockup because I need to get everything to the jurors.
Yes, sir.
Once the jurors are all set and have begun their deliberations, we'll bring Mr. Carr right back out. I will hear from Ms. Hall on the state's perspective. I'll be interested, Ms. Hall, in hearing what you believe connects Mr. Carr to the case based on what we've heard about some of the factual recitations from Mr. Cruz. And then certainly I'd be interested in hearing your perspective as to what should happen with bond. But we're going to take about a 5-minute break so that poor Deputy Gordon can do the shuffle down to 8F. We'll get you out here in a minute, Mr. Carr.
Yes, sir.
May I speak with him, Your Honor? May I go to the back and speak with him?
So you have to talk with the deputies about staffing. I'll get off the bench once I know things are heading down to 8F. It's just a question of what kind of staffing they can support because one deputy's got to leave the courtroom.
Yes, sir.
All right?
Thank you.
But I don't have a problem with you doing that. It's just whether they can support that.
Yes, sir. Thank you.
Yep. All right. Is everything done now because there was this extra time?
It's done.
Then I'm going to give the verdict form and the jury charge to Deputy Gordon. Do you need something to get their electron? We have a little basket we use. If you check with Ms. Hansberry, she'll give you, it's like what they deliver Coca-Cola in or something. It's a tray. She can help you get that. But you may want to bring all that so that you can leave with their electronics. And that one juror can keep the Apple Watch. So, Mr. Cruz, you can check with the deputy. I'm going to leave the bench until I learn from Deputy Gordon that folks are all set up in the jury room. Then I'll come back and we'll pick up with Mr. Carr.
Yes, sir.
Yeah. This is the box.
About right here.
Sorry.
You didn't be getting here?
Okay.
You're on that trial diet, not even on trial yet.
Sure. How you doing, Ms. Rivers? Okay.
No, we were all wondering. Devin, I'm gonna go down to the first, see if they have a dedication. Needed.
Alright.
Powerade. Water.
The
Yeah, so the TBI process is.
So it's
Whether
basically-
the process. Another age, where it's that's the
So the science of it.
yeah, so that is something that's yeah, it's like, you know, people. We process the same.
They test. Yeah.
Yeah, actually, they're trying to do.
Oh, it's not. I'll hold the science of that.
Yeah. Because that's like, let's keep questions. Just put it natural.
I guess we got a lot, like when you said call and have please orchestrate that question, so.
Yeah, I don't know what their compliments is, but they have it.
I don't know. Yeah, this kind of stuff.
This, just so that. You was like whatever you want to go, but.
What kind of water?
Yes, please. We need Ms. Rivers, not that, a different court reporter. We'll check on her.
I think she's right here.
Okay. Mr. Franklin, were we gonna chat with Mr. Kojo? Was that how, or you haven't had a chance to chat with him?
He wants to speak with you.
Okay. Is Karen back in our office? I don't know what he do. He may be looking for the wrong court reporter. Okay. No, our court reporter's coming. Yeah, the court reporter for the civil case, I've got a phone number to call, but Ms. Rivers just was back in the office. So we're good. All right, you ready? Okay, we're back on the record in Mr. Carr's matter. I had heard from Mr. Cruz about why Mr. Carr should get a bond. I got to hear from Mr. Carr's stepfather and his mother, and there were a number of other family members and friends and supporters who are online in support of Mr. Carr. Mr. Cruz, one question before we pivot to Ms. Hall to give the state's perspective. I don't think I heard it, but I may have missed it. What is a reasonable bond in your mind? You mentioned ankle monitor might be okay, could be house arrest. Mr. Carr's wife, Erica, is anxious to get him out to Douglasville to help take care of the kids. He can work, et cetera. But what is the dollar amount that you think is this is not a signature bond eligible set of crimes? So there needs to be a dollar amount set. I was curious what you felt was reasonable / capable of being posted by your client's supporters.
Yes, sir. And if the honorable court will allow me to explain the number, just to put it into context. So of course, as the honorable court knows, the purpose of bond is just to ensure, at least the amount, to ensure that this individual will return to court, a sufficient amount to make sure this individual will return to court when it's time to return to court. Mr. Carr's family, from the discussions that I've had with his mother, stepfather, they work as a unit. They're not a wealthy family. They're not a family of a lot of means. They're a family where each person plays a very important role in making sure the well-being of the family as a whole is taken care of. We do understand the seriousness of the charges, but there are many individuals who are willing to make sure Mr. Carr is here. They've hired counsel in full. I've worked with them to make sure that that's something that they were able to do. So we would ask if the honorable court is willing, of course, a reasonable amount for the court, but something that we do know that the family is comfortable with would be a $25,000 bond.
Okay. Thank you. Ms. Hall.
Thank you, Your Honor. So, Your Honor, I just want to start with the state's position is that the bond status for the defendant remains as is. And just to give you clarity, I know you said that you wanted to know the connection between the defendant and the charges or with the victim. In this case, this is not an identity issue, not as much as the defense counsel kind of led with. The victim knows, or not knows as in friends, but he knows the defendant in passing. Hence, that's why he was able to give police officers the whereabouts or where he thought that the car that was involved in this aggravated assault could be located. Excuse me. He did give the name initially when officers arrived on scene as Twin, being the person who he said he goes by the name of Twin. The officer did note that he was in extreme pain, and that was really the only word that he could get out of him. When he was out of surgery after losing a kidney to the crime that happened against him, he did speak with officers again, and he did give the name of Drizzle, and he said they call him that because of his dreads. I know that defense counsel did go over the facts, so I will not repeat most of them, but I will highlight some things. This is something that happened at 4:30 in the afternoon at a gas station. It wasn't particularly behind the gas station. It was on the side of the gas station. At broad daylight, this car pulled up to this gas station and shot into this vehicle. The victim, he covered the driver of that car. That's why he ended up being shot in the back and the shoulder. After being shot, he jumped out of the car to get inside of that convenience store to call for help. It should be also noted that the car that was involved in this crime was caught on Vic cams. Your Honor, we actually have the photos of those, the captures of the vehicle on the Vic cam, and the registered owner, when officers were able to pull the registered owner of that vehicle after they started their investigation. The registered owner of that vehicle was the defendant, Mr. Carr. And that was after the investigator went out to the area and location in which the victim said they probably could find the car. The officer was able to locate the car, which had the same dent that is visible on the Vic cam picture. That car did speed off from the location when the officer was trying to investigate the tag number and run that tag, but he was able to get the full tag, and that car came back to Mr. Carr. Mr. Carr, it wasn't an individual picture that was taken to the hospital for the victim to identify who shot him. It was a 6-pack that was created, and there was an officer that was not involved in this case that presented that 6-pack to the victim, where the victim positively identified Mr. Carr. Now, it's just hard to believe that we're saying that the Mr. Carr, who is allegedly the culprit of these crimes, was coincidentally the same car, the person that had dreads, a person that the victim is familiar with, that he knows is in the area of town in which this car was located. And he feels as though because he knows this individual, or he knows of this individual, that this was an attempted armed robbery because he had a gold chain on that day when he was in the parking lot with the female Miss Blake. Now, Miss Blake didn't have much to say to investigators, but she did relate to officers that she thought the two individuals, meaning the victim and the defendant, knew each other. She didn't say why she felt that way. She just said that she thought that they knew each other. That was the gist of what her eyewitness account was. But Your Honor, the state asks that he remains in the status that he's in as far as no bond on this case, because once this case was printed publicly for us to have this our bond hearing, we have lost contact with our victim. We did have contact with our victim in February and March of this year, because we had the upcoming calendar in April. Since this calendar was publicized, we have not made contact with our victim. And I think it's important that if this defendant does get a bond, our victim is aware of that, because there is a potential of him intimidating our witness, the defendant intimidating our witness, especially if we believe what our victim is telling us, that he knows, and he knows of this person, and he knows at least one spot where he hangs out at. I also would say, as far as the Ayala factors, the defendant is a danger to the community. Any person that decides to shoot in a gas station parking lot 3 times into a vehicle that also had the mother of young children in it, we don't feel should be out on bond, Your Honor. We also have made an initial offer to the defense counsel of the defendant serving 3 years, at least 3 years in prison for this alleged crime. Although that is not a solid offer, because my contact with the victim has vanished at this point, I did inform the counsel, Mr. Cruz, that offer could go up or down depending on the conversation with the victim. But the victim did lose a kidney from this situation. This is not just a shot at someone and no one got hit. This person was shot directly into a vehicle in close range. He could have not survived his serious injuries. So and as far as the criminal history, Your Honor, I did look at the defendant's GCIC. As I stated to Mr. Cruz, it looks like it's a disposition as far as the disposition, but it's not clear on the GCIC whether that was an actual conviction or not. So I cannot confirm. I'm sure Ms. Woodward will be able to but I believe that's out of state. I did reach out to Ms. Crawford. She couldn't confirm because it wasn't in the state of Georgia, but that's all the information that the state has. And I believe that's all the information. Oh, if you are inclined to give the defendant a bond, Your Honor, the state asks that the bond be $80,000. as well as a condition that he wears an ankle monitor. And that is mainly because I want to have time to locate the victim or relocate the victim and talk to him about what's going on so that he is aware that, if the defendant is out on bond, he's aware that he's out.
Ms. Hall, is discovery complete as far as you're concerned? Or are there things stuck at GBI, or how are we doing with discovery?
Sorry, I meant to speak on that as well. I did receive discovery earlier this week. The only thing that I'm missing is one video. I did go ahead and email that link over to Mr. Cruz, so he should have that. I did email that over to him today. I wanted to go through it and see everything, make sure I had everything. I'm just missing one video, but the discovery is complete, and it's photos, well, complete minus that one video, but it's photos, videos, the Vic pictures that I mentioned, all the interviews, witness statements, and everything that Mr. Cruz will be looking for, and also the six-pack lineup.
You said one video is missing. There are other videos included. This would just be one of the several surveillance videos.
So no, it will be the body cam videos from when the officers arrived on scene. The videos that I have right now are all of the surveillance videos from the gas station, from the Vic cameras, and all of that. I don't have the actual body cam videos. It's been requested, and I should have it either today or tomorrow.
Okay, and this would be body cam footage of what the gas station scene was like after whoever the shooter was gone.
Yes, Your Honor.
Okay, all right. There's a motion for speedy, there's a demand for speedy trial filed. So this is a case that is going to move more quickly than it has. It seems like it's a timely demand for speedy. The indictment was in March, so it was filed in the same term, the March-April term. So this is a case that we'll be prioritizing as we start standing up our own trial calendars, which we hope to do towards the end of August. All right, that is helpful information. Let me get from Officer Woodward. Does anything show up in terms of an adult criminal history in Georgia?
No, Your Honor, it shows there's no prior felony convictions.
Okay, thank you. Mr. Cruz?
Yes, sir.
Any final word from your side?
Yes, sir. Two main things. Of course, I'm well aware of the Honorable Court's credentials and experience in this, but we get into the areas of determining guilt or innocence when it's asked that based on the allegations alone that this individual is a threat to the community because XYZ occurred. Of course, the Honorable Court knows the purpose of bond, as spoken about earlier. There is nothing based on Mr. Carr's record that shows that he would be a threat to the community or a danger as far as violent harm to individuals in the community. There are multiple individuals on the call that say, hey, we're going to put everything we have up for Mr. Carr. We're going to ensure that this gentleman does return to court. I think the biggest thing here, though, and the reason that we are asking for bond and the reason that we do have the speedy trial in, when the state mentions that they've spoken with the victim, I'm not sure if it's Miss Michaela Blake, and I'm assuming it's Mr. Owens. The only issue with that is from our investigation, what was revealed is that Mr. Owens is currently and has been for a good period of time in custody for some very serious charges involving assaults on officers and things of that nature. So unless we're speaking to Miss Blake, there would, based on information that we have, there wouldn't be a way to contact Mr. Owens unless there are jail visits taking place or he's calling the DA's office stating, hey, I want to talk to the prosecutor about the case down in Atlanta.
So I thought your bond motion said, I have no idea where the guy is. Now you're saying you know where Mr. Owens is?
May I look at the bond motion, Your Honor?
Well, I've got it right here. I thought that you indicated in your bond motion that there had been efforts. There was a Mableton address and you spoke with the person there. Haven't seen the Mr. Owens since summer of 2020. She doesn't have contact with Mr. Owens. And that's it. You also alleged that the state had tried to reach Mr. Owens and hadn't been able to do so.
Correct.
So if we know where Mr. Owens is, that actually makes everyone's life a lot easier because we can get Mr. Owens here. You think he's in the state system?
No, sir. He's not in the state system.
Okay, you think he's in a local jail that's not Fulton County?
No, he's not in from the criminal history, because all thing we can get is his criminal history. That was the only thing we could really locate on him when we tried to do our own investigation to locate him.
Yeah.
But he's facing some very serious charges out of state involving, and I don't want to misstate to the court. I know it was involved in some type of violence with or against a police officer. But that was the most that we could come up with. So.
And you think he's in custody out of state?
I do believe that based on the seriousness of those charges.
Okay. What's your sense about discovery? You feel like you've got discovery minus some body cam video of part of the interaction that wouldn't directly involve your client?
Well, I trust Ms. Hall's word that the link has been sent to me today, but from what I've had opportunity before today to put my hands on, all I had was all that we have are the police reports.
Okay. All right, anything else you want to add?
No, sir, Your Honor. We would just ask that the Honorable Court takes everything that we put before you today, take that into consideration. We would also just simply ask that based on the issue that we do believe the state is going to have with getting a witness here to trial, that Mr. Carr is allowed an opportunity to defend this case out on bond with restrictions that the Honorable Court puts in place.
Mr. Carr, I asked you before, but now I've heard a little more through Mr. Cruz about the two competing addresses that you have. It sounds like your mother and your stepfather are willing to let you stay with them, but that your wife would prefer you go there so you could help out more directly with taking care of the kids. Are you neutral as between the two, or what makes more sense?
I have no preference, but it'll make more sense to be with my mom. They're closer to the court system.
Well, but you won't be coming here all that often. So I would want to designate as the address the one that you think is going to be safest. And by safe, I mean it's going to keep you out of trouble and keep you on point with working and showing up when you do need to come to court. But I don't want you to think that you've got to come to court once a week or anything like that. It wouldn't be like.
I would be comfortable with my mom for work because work is right there and everything. And it'll be easier with transportation.
Okay.
And the family is, that would be the best place just as far as keeping everything within the city.
Okay. All right, so I don't find that Mr. Carr is a flight risk given his connections to the community, born here, mom still here, stepdad here, wife and kids here. So the primary factor about the likelihood of Mr. Carr appearing in court when he's next supposed to be here, I don't think that militates towards denying bond. I do think it's appropriate to consider the nature of the allegations when considering the threat to the community that Mr. Carr might pose. I appreciate Mr. Cruz's observation that Mr. Carr is presumed innocent of these charges, and that is very much the case, but it doesn't mean that we ignore the nature of the allegations. That said, I do find that there is a set of conditions that I could impose that I think would, given the fact that Mr. Carr was last in trouble over a decade ago for having some marijuana in Iraq while he was serving as a Marine. I do think that there are a set of conditions that I could impose in this case that would assure, number one, Mr. Carr's appearance in court, and number two, the safety of the community. I am going to set a bond. I will set it at a total of $50,000, 50 followed by 3 zeros. It will need to be a good bond. Actually, it's going to be through the sheriff's 10% program, as opposed to through a bonding company, so that we can get pretrial supervision, which will be at level 2. If and when Mr. Carr makes that bond, it will be necessary for Mr. Carr to start out with an ankle monitor. If we go a few months and there are no issues with Mr. Carr being where he needs to be, et cetera, ankle monitors are not free. And I don't mean for the money you earn at State Farm or doing roofing or whatever you're doing to go only to the ankle monitor company. It ought to go to your kids and your family, et cetera, as you take care of them. I will require that you reside at the Magnolia address, which I have as, make sure I'm right, 526 Magnolia Street, apartment 53.
Yes, sir.
In Atlanta. That's where you're going to need to stay, as in, that's where you spend the nights. Doesn't mean you can't go spend time in Douglasville with your wife and kids, but you will have in lesson until you get a job that requires you to be out late. You'll need to be at that Magnolia Street address between the hours of 10 p.m. and 6 a.m. The ankle monitor will help ensure that that happens. You also need to stay off of Joseph E. Boone. The gas station where this happened was on Joseph E. Boone. Stay off that road. No contact with Mr. Owens or Ms. Blake. You don't call them. No one you know reaches out to them to say, hey, why are you making this stuff up about Mr. Carr, or whatever they might be doing, or to find out how Mr. Owens is doing with only one kidney. You need to have no contact with him at all. And you need to make good efforts to maintain employment. These days, it's pretty easy to get a job because everyone's hiring. So I would hope you could pretty quickly get working again. I need to break the dollars across the 7 counts. So it's $10,000 for counts 1 and 2. And then it is $10,000 for count 3, and then $5,000 for each of the remaining 4 counts. That should be 30 plus 20, gets you to 50, which is the bond amount. Mr. Carr, your lawyer did file a demand for speedy trial, which means we need to move this case along. It'll move pretty quickly. Mr. Cruz will need to be ready at each juncture. If he asks for a continuance for any reason, that'll mean we need to get that demand for speedy trial out of the way. But the good news is we are moving to having more and more in-person trials. So if the goal is to get this in front of a jury, by the time we would naturally get there, Mr. Cruz having a chance to look at the discovery, figuring out are there motions we need to litigate, will be aligned with getting a jury about that. Ms. Hall, any other conditions that you wanted to see on the bond?
No, Your Honor, you covered them all.
Okay. Mr. Cruz, anything else?
No, sir. I just want to thank the Honorable Court.
Okay. You can stop calling me that, but you're welcome. All right. That's it. Any questions, Mr. Carr?
No, sir. Thank you, sir.
Okay. Good luck.
May I be excused, Your Honor?
Yes, sir.
Thank you.
So if we could bring, when you're ready, Mr. Kojo, do you want Mr. Kojo at the podium or just at the door?
I think it'll be the podium because he speaks really well.
He does.
Won't hear it.
Okay. So if we could bring Mr. Kojo to the podium, when we're done chatting, then we'll bring Mr. Tatum out and hopefully take a plea.
And I should not recognize that Mr. Kojo's father's presence.
We've already reconnected. You, same to you. I don't know, Mr. Cruz, was he with your office at some point, or he's just set up his own practice?
I'm not familiar with him. Are you familiar with Mr. Cruz?
The defense attorney who was just here?
Trying to face the judge right there.
Hello, Mr. Kojo, how are you?
Not good. I'm having serious health problems.
Hold on one sec. You're having serious health problems.
Yes,
I'm sorry to hear that. What kind of health problems?
laying down in this 212 room. Some type of, I don't know, some type of device, floor magnetic device, something, just have a rubbing feeling on my prostate area and my anus and my scrotum and penis. Somebody has somehow wiggled my prostate. It's completely gone now. Somehow when I'm trying to sleep, somehow compressing my colon and my intestines and my anus from trying to sleep, trying to get my sleep from some.
Have you had a doctor check things out?
Air and things. Making some type of no noise through the floor, messing up my brain and body. Something compressing my lungs. I can't breathe properly. Developed diabetes in the jail.
Are you getting any medication?
No, I need to go home. I'm having health problems. In case of something dismissed.
Do you talk to the nurses or the doctors about your health problems?
Yes, but they didn't take me to the physical doctor to be seen about them. I spoke to the nurse on some.
Are they helping you with the issues or not?
I just need to.
You need to go home.
I need to help somebody else that's not doing that regarding these things. About my prostate and everything else because of a transplant, something crazy.
Okay, I'm hearing about the prostate. So,
my feces and stuff is backed up, and they've done something to my eyesight in February 2021. Somehow wiped my
what's wrong with your eyesight?
Somehow showing visualize image things against my somehow able to compress my lungs like this.
Hard to breathe.
Sometimes.
Okay. Well, Mr. Kojo, I know that folks are working to figure out a next step that makes sense for you. I know you want to go home. You told me that before. Your father's here. He and I had a good conversation. We just need to make sure it's safe for you to go home.
Regarding somehow able to compress my urethra when I'm trying to pee as well. I just need to go home to my family. Having trouble.
Okay, well, I know you want to get back there. We need to make sure that you are healthy and sort of in a good state before that happens. And you have these new charges around a situation that we won't talk about today, but we are going to need to talk about soon.
My case, if not case is dismissed.
Mr. Franklin?
One of the things that Mr. Kojo expressed to me that he wanted to talk to the court about, I tried to explain to him, but he disagrees. He believes that his new charges have been dismissed.
Okay.
I was brought here with March 31st or April 1st, 2020. I had my first appearance, April 1st, 2020. It was at an April, May, June, 3-month window. It was not indicted. It was dismissed.
So I can understand why you would think, gosh, they must have been dismissed because
was going to court. Some guy came up with an ankle monitor and everything else. I'm like,
It's been a long time since those charges were brought, but because of some of the same health reasons you've been talking about, it's been hard to get charges turned into an indictment. And they're working on that. But I know you wanted to share a few things with me. I appreciate you doing that. It sounds like I may need to work with the medical folks there to make sure you're getting the attention you need.
I need to go and see an actual normal, proper physical doctor and to get proper sleep stuff and everything else.
Do you ever get to go over to the hospital to get medical attention, or is it always just there at the jail?
I've never been seen by anybody at the jail running this. I have serious physical health problems where my brain and my colon test and some type of magnetic device or vibrating device to the floor. This 212 room and 207 rooms. You probably already know. I need to be seen by doctor and to go home with my family and mother and things.
Well, like I said, your family is anxious to get you to a good place. Like your father's here, and he and I talked about that. It's not quite time to do that when you figure out what's going to happen with the new charges. It involves some pretty serious allegations about a gun and things like that. And that was new for me working with you. So we're going to need to make sure everyone can be safe with whatever the next step is.
Somehow possessing my body with some type of voice programming that caused me just trouble and problems in the jail. It's for sure it's time for me to go home because I'm having serious trouble which is never deal with this regarding me trying to get back my ability to take my full deep breaths again regarding the things and September 4th, September 8th, 2019, which was caused all these trouble problems leading up until March 2020. Which I finally figured out by breathing properly to a small degree regarding the Wim Hof method, then took to a higher level in the jail, and all the types of devices in the floor, causing all these trouble and health problems, and the time period was enough in the jail based off what day time frame scheduling and things like that. It just
well, when we next meet, we can talk more about this and figure out what the right plan is. But we don't have a plan in place right now. So it wouldn't be okay just to send you home because we haven't figured out all the steps that we need to take. Okay.
Actor wrong thing with performance of a song nonsense and to continue to disrespect this incredible nonsense English and you have to contemplate about back then who I need Kaiser doctor or this lady that come to rob from me and what was it? Now they're making this regarding me into my full breaths again. Things which are somehow blocking me involved somehow messing with my brain. National device to forward the same for.
All right. Well, Mr. Kojo, I'm gonna wrap things up for today. It's good to see you.
My probation verification because based off what I went over my case.
Can you say that one more time closer to the microphone?
And today's supposed to be my probation verification because based off the court date time frame schedulings and all that, both my two cases are dismissed. Like first appearance, I think what was it 1-2 days of being there, preliminary 14, 21 days. And then it's dismissed. And,
so you are correct that today was a day when we might do your probation revocation, but the new charges involving the Uber driver and Ivy, those aren't ready yet. And so
those were the ones from back then.
So we're not going to do the probation revocation today, but when we next talk to each other, we can figure out whether we're going to deal with that or come up with a different plan. Okay. I'm going to have you go with the deputy.
We have to talk to each other about. I would not like to be involved in some type of act along game regarding any phone call or text, anything like that. Not any, like you really want to not any video visitation thing between my mother. I just
You would or would not like that?
Not like that. I just would like to know.
We won't do that then.
What's going on with my cases so I can go home.
So that's what I was trying to give you as an update on your case. You've got the old case where we had the revocation. You've got the new charges, but they're not ready yet, and we need to get them ready. Okay? All right, I'm gonna have you go with them. So we'll need to get Mr. Kojo back here. What did I write down? But we'll set it out to try to encompass an indictment date so that there are new charges by then.
So the question that I would ask for the court, I've never had to approach it from this posture. He has the unindicted case, and typically the person who has the attorney that has that will handle any ex parte requests. And I'm not sure, being that we would not necessarily be the court that would inherit his indicted case.
Right.
But we certainly have
this
competency-ish questions for, as it pertains to the revocation. Would it be appropriate to seek?
I think we should start the process.
Okay.
And then it will be your office that gets the new case. And so hopefully left and right hand can connect to say, we already have Dr. Egan, whomever, doing some work on this, because it'll apply to both.
Yeah.
It's happened before. I don't remember if Miss Korean or Mr. Hobbs or it would have been one of them worked with Mr. Kojo on the older case. But we reached a point where with medication, we're able to have more of a dialogue. I don't know what the clinical status is right now out at the jail.
Understood. I'll at least have papers when we have court tomorrow.
Okay.
Present them for your signature.
Thank you.
Yes, sir.
So if we could have Mr. Tatum come out, we will take that plea.
You'll stand right here. This is the prosecutor, Ms. Hall. And this is Judge McBurney. Your uncle is-
So you attach the indictment to the calendar so I can just print it out. Oh, that's right. I do it electronically. Forgot about that. Okay. It's been a minute. Okay. But I've got it. Okay. Ms. Rivers, are you ready? Ms. Patel?
Yes, Your Honor.
Great. This is case 19 SC 173787. It's State versus Daryl Tatum. Hello, Mr. Tatum.
Hello, sir.
How are you?
I'm okay.
Good. I'm Judge McBurney. We are here today to talk about whether you want to enter a plea in your case or not. Are you ready to go forward?
Yes, sir.
Great. Ms. Patel told me that she thought you were ready. The prosecutor is a woman by the name of Ms. Hall, and you will hear her just fine. You'll be able to see her some on the screen that is to your right. And she's going to be asking you a bunch of questions. Are you ready to answer her questions?
Yes, sir.
If anytime she asks you a question that you don't understand, let me or Ms. Patel know so that one of us can explain what is meant by the question, okay? Yes?
Yes, sir.
Great. There are no trick questions. No one's trying to trick you. If a question isn't clear, we need to ask it in a better way. But it is important that you understand the things before you answer them. You're going to be under oath, so your answers need to be truthful and they need to be complete. If you need to take a break at any time to talk with Ms. Patel about whatever it is you want to talk about, just let me know and we'll take a break and you two can talk. Will you do that?
Yes, sir.
Great. So, Mr. Tatum, Ms. Hall is going to take over now. She's going to ask you to raise your right hand and she'll swear you in and then we'll go from there, okay?
Yes, sir.
Ms. Hall, are you ready?
I'm ready, Your Honor.
Great.
And Your Honor, for the purposes of this plea, the state is no processing counts 5 and 6 on the indictment, which are possession of firearm during the commission of a felony. That's both charges.
Dismiss these two.
And then 1, 2, 3. The 4 counts of possession of firearm by a convicted felon will also be null processed by the state.
1, 2, and 7.
So counts 1 through 4 remain and count 7, obstruction of a law enforcement officer, remains.
Yes, Your Honor.
Okay, thank you.
You're welcome. It is our intention to deviate from the mandatory minimum, section E of the statute.
Okay.
Mr. Tatum, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Daryl Zachary Tatum.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, I took my medication this morning.
The medication that you took, will it affect your ability to understand what's going on here today?
No, ma'am.
Okay. How old are you and how far have you gone in school?
I'm 38 and I dropped out in the 10th grade, but I've worked on my GED some. I passed the pretest and last time I was in prison.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses: armed robbery, criminal attempt to commit armed robbery, 2 counts of aggravated assault with a deadly weapon, and 1 count of obstruction of a law enforcement officer?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
That was just 1, 2, and 7. Right?
2. These 2 merge with that, and then 7.
What do you
These
mean?
are gone. So the judge will be to merger later on in the plea, but basically on your sentence sheet, these 2 counts will show as being merged with these 2 counts.
All right.
Did you have enough time to speak with your attorney, Mr. Tatum?
Yes, ma'am.
Okay. Do you need any more time to speak with her?
No, ma'am.
Okay. Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
We waive.
Mr. Tatum, have you been arrested on these charges?
No, I haven't. I mean, in the past.
That's what she means. Like back when this happened, you were arrested at some point in connection with this armed robbery?
Do you remember being arrested at the Quick Trip?
Yes, sir.
And I ask you that, Mr. Tatum, because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We do not.
Okay. Mr. Tatum, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum for armed robbery is the minimum 10 to serve 20 years or life imprisonment. The minimum maximum for criminal attempt to commit armed robbery is 5 to 15 years to serve. The minimum maximum for aggravated assault with a deadly weapon is 1 to 20 years to serve. And the maximum for obstruction of law enforcement officer is 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of for the armed robbery count and the 2 aggravated assault counts, which we believe will merge into the armed robbery, will be 10 years to serve 5, balance on probation. And for the criminal attempt to commit armed robbery, 5 years to serve. And for the obstruction of law enforcement officer, 12 months probation. As well as we will recommend to the court that the court recommends RSAT while you're in prison, and that you be assigned a mental health officer as your probation officer once you're released from prison. But the court does not have to accept that recommendation. The court can sentence you to the maximum on these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
So basically, as we're going to trial, where you would waive the defenses of mental health like that, you waive those because we're entering into it today.
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 19-SC-173787, how do you plead to the charges of 1 count of armed robbery, 1 count of criminal attempt to commit armed robbery, 2 counts of aggravated assault with a deadly weapon, and 1 count of obstruction of a law enforcement officer?
Guilty under Alford.
Ms. Hall?
I'm sorry, Your Honor. Okay. I'm sorry. My apologies. I'm moving forward. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Are you freely and voluntarily, is anyone forcing you to enter this plea?
No, sir.
It's something that you've chosen to do after talking about it with Ms. Patel?
Yes, sir.
Okay. Has anyone promised you anything other than, it sounds like Ms. Patel, as your lawyer, has talked with Ms. Hall about a possible sentence you might get. But other than saying, hey, we're going to ask for 10 to serve 5, has anyone promised you anything?
No, sir.
Are you comfortable moving forward?
Yes, sir.
Okay.
Mr. Tatum, do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for misdemeanor to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
And are you also aware that you only have 30 days from today to file an appeal on this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of 5 prior felony convictions by the defendant dating back to 2003. That was out of Fulton County, which was a theft by shoplifting. There's another conviction of a drug conviction in Gwinnett in 2005. And then the latest conviction was a aggravated battery out of Miami-Dade County in 2014. And had this case proceeded to trial, Your Honor, the state expect the evidence to show that on November the 8th and on November the 13th at 956 Ponce de Leon Avenue, that's in Atlanta, Georgia, Fulton County. Those were the dates of the alleged crimes. But on the 9th of November, one of the victims went into the police station to report that on November the 8th, he was robbed by the defendant. The victim stated that he had went to the Bank of America on Ponce. He withdrew $140 as he was walking back to his vehicle. A person that looked to be homeless approached him, asked him for his money. If he did not, he refused a couple times, the victim, and then he eventually gave over his $140 to the defendant. The defendant ran off. Not before the victim saw the defendant brandish a gun, what he thought to be a revolver at the time. There were 2 witnesses that were walking that witnessed this armed robbery occurring. They attempted to follow the defendant. In the police report, it did report that there was a loud pop that the victim heard when the 2 individuals was going behind the defendant. Then fast forward to November the 13th, there was another attempted armed robbery at the same location, 956 Ponce de Leon in Atlanta, Georgia. In this case, the defendant brandished the gun as well. The victim, however, refused to give over his items. There was a struggle between the 2. When the victim made it home, he realized that he had been shot. Well, he saw blood coming from his shirt, so he did go to the hospital. He was shot, but it was later found out that he was shot by a BB gun, not an actual handgun. So he has since healed that particular victim. The victim in the first case did a sketch of the defendant when he was armed robbed. That sketch was that sketch was used. Eventually an officer was able to identify someone that matched the description of the sketch. That person was put into a 6-pack. One of the victims did identify, both of the victims identified the defendant as the person who armed robbed one and attempted to arm rob the second victim. I'm trying to think if I'm forgetting anything. I've spoken with both victims multiple times. The victim who was actually shot in the case by the BB gun, he has since healed from from his injury that he had. He has some type of injury to his stomach. He has healed from that, and he, in our conversations, as far as, and this is one of the reasons why we have been able to come to this negotiated plea. We did in our investigation in this case find out that it was not a real gun that was used in these robberies, and the victims in both cases did observe they felt like that the person who did arm rob them had some type of mental health issues going on. And my second victim, who was actually the only one injured in this incident, didn't want that person to face any prison time, but more so get help for whatever they were going through. Of course, our office, I've spoken with Ms. McCauley about this case several times, and the best that we can come up with, even with any type of mental health that he is dealing with, was this negotiated plea of him serving still 5 years. That is why my recommendation to the court is that it be recommended that he completes RSAT. So he is being treated while he is in prison. And then once he's released to a mental health officer for his his conditions. I believe that is all, Your Honor. There are no victim impact statements today. No one wanted to actually appear for the case, but they did want me to relay to you how they felt. One being that he just wanted the person to get help. The other being that he did want him to have some type of time in prison for what he did, because he is still suffering from being armed robbed, even though it wasn't a real gun. He still had the effects of him going through that night. That is all from the state, Your Honor. Oh, and I'm not sure if I mentioned the obstruction charge is from when the defendant was arrested. He was attempted. The investigators were trying to question him, and it became more of an obstruction. He started to throw the tables and chairs. That's where that charge came in at.
Okay. Thank you.
You're welcome.
Just looking at the indictment. Okay. Officer Woodward, I heard about Mr. Tatum's criminal history from Ms. Hall. Does Mr. Tatum have any open, active cases in Georgia?
No, Your Honor.
And it sounded like the most recent felony was out of Florida. What's the most recent Georgia felony that you have?
One in 2008 in Franklin County. That was an aggravated assault case, as well as another one in 2008 was theft by receiving stolen property back in Jackson County. Nothing further.
Okay. Thank you. Ms. Patel.
Thank you, Your Honor. I'd like to start with just briefly discussing the case. My client is connected to this case because of two identifications in a lineup. He was not arrested with a cap gun or a BB gun. There was no money on his person other than some spare change. He was arrested in Midtown by the Quick Trip that is sort of in the center of Midtown. And so the crux of this is
the non-gas station Quick Trip?
Correct.
Just the store?
Correct.
Okay.
That's where my client typically panhandles. And there was a sketch that was done, Your Honor. I believe it was actually the second victim that had created this sketch, and arguably it does not look like my client. These are all things that we considered in whether or not to go to trial. There were big differences in the sketch. The lineup wasn't great in the sense that there were some clean-cut guys in the photo array that didn't necessarily have the same type of hair as the sketch or of what Mr. Tatum was sporting at the time. With that being said, Your Honor, the reason that we're here today is my client has had quite a difficult background that has led him to where he is today. He's been homeless for a very long time. His mother was schizophrenic. His father suffered from a drug addiction. I believe he passed when my client was around 7. His mother was institutionalized and was unfit to take care of my client and his brother. So they ended up remaining in foster care until they aged out of the system. My client was diagnosed with ADHD when he was a child, eventually major depressive disorder, then schizophrenia, then autism. And at a very young age, I believe around after 18 or so, he had a couple stays in Georgia Regional, but he has not had any meaningful mental health treatment in the past 10 years. That recent incarceration in Florida was a straight prison sentence. There was no treatment or anything as a part of that. My client has an uncle, Kit Tatum, he is in court today, who reconnected with my client and has a financial means to help my client. And so in 2019, he does not live in Georgia. He lives up north. He tried to get Daryl seen by the Price Counseling Center. So my client did end up going to this counseling center. They evaluated him. They did note the intellectual disabilities as well as the mental health components, but they believe that they were not specialized enough to help him with his issues. So they gave Mr. Tatum just a referral to Lakeview. And that's sort of how things ended in 2019 for him. I received the case when I first met Mr. Tatum. He was in a very different state of mind than where he is today. I think that most of our interactions did not go well at first. We had a very difficult time talking and even discussing the case. So I'd filed a psychiatric evaluation. And then in the meantime, my social worker worked to try to get him on medication at the jail. We got him onto an antidepressant, which has really helped with his mood stabilization. There was points where he was feeling really down, which I think that has helped with. In the psychiatric evaluation, they did note that he, in the jail records, had a history of delusions, hallucinations, all these other things. But because he, at the time of the interview, was not actively facing any of those, they did not find him incompetent. And me and Ms. Hall were hoping that restoration would sort of help us onto a path of potential treatment down the line. So once we found out that he was found competent, Ms. Hall and I discussed behavioral health treatment court. She discussed that with her victims and whether or not that would be something that they would be open to. And they both were on board. Ms. Hall did her best to pitch the idea to Ms. McCauley. Of course, it's a big ask to say, will you take this risk on someone you don't know, you haven't met, on an armed robbery and an attempted armed robbery? And so the best that Ms. McCauley could offer is what we're dealing with today. It's unfortunate because I do think that when Mr. Tatum is guided, and I think that the court is something that he would feel that guidance from, he can do certain things. I think that the problem is his uncle doesn't live in Georgia. The only other person that lives here is his brother, who is holding his life together by a thread. And so his brother can't be responsible for Daryl, nor does Daryl want him to either. And so I hate the idea of taking a plea and not having something in place for him, which is why we are asking for that recommendation of RSAT. We know that it's up to prison what they decide to do. But with that being said, his uncle, who we'll talk about this a little bit later, has the means to, unlike many of my other clients, provide him with meaningful housing that's in a safe part of town, provide him with transportation, a cell phone, whatever it is to keep Daryl on his feet.
Why would Mr. Tatum why would he return to the Atlanta area if the only family here is his brother? He's going to serve some time in state custody when he's released, why not be, what is it about Atlanta that would bring Mr. Tatum back?
Simply that he's from here. This is where he was born and raised. Of course, he could have the option once he's released from prison of transferring his probation to where family would be. But I believe that initially when we were looking into BHTC possibly being an option, his uncle was looking into buying a piece of property that he could have. The idea being have Daryl and his brother sort of fix up this property so that they are working, they are busy, and then they are incentivized by living in this property. But that idea kind of fell through once the program became no longer an option.
Yep.
So his uncle is certainly flexible to whatever it is that Daryl's going to need once he's out. Certainly it requires Daryl being the active and willing participant in all of this. I will say that we struggled with getting him on the right medications at the jail. They did not want to prescribe him with anything more than the antidepressant, because when he would have his appointments, if he wasn't actively suffering from the delusions, they didn't want to put him on anything more. With that being said, there's actually been some success in Daryl's past with the prison figuring out the right medications that he needs. So I'm really hoping that the schizophrenia is treated with more than just an antidepressant, which has just really been just helping him get through his jail situation. His brother has been really torn up about this case. He wanted to be here in support, but he said that the only thing that he would tell the court is that he doesn't believe that his brother should be in prison. He's very upset by what's going on, but Daryl, his uncle, his brother, we've discussed the risk of trial is just too great for him. And his brother actually is the one that talked to Daryl a lot about taking this offer, because he's worried that if Daryl gets a life sentence, that'll send Daryl into spiral, and that he'll never see his brother again. And so it took us a long time to get to where we are. And I am happy that Ms. Hall has been working with us at every step of the way towards this resolution. I am hopeful that Mr. Tatum is able to stay out of trouble while he's on probation, but I do believe that a very, very small silver lining is that should I get the revocation, I can actually put him into a program once he's out of prison. Hopefully he will not have any issues on probation, but that is the other rationale. And his uncle is here. He'd just like to talk a little bit about Daryl's situation.
Okay, sir. Deputy Gordon, you're periodically checking on our jurors.
Yes.
All is well? Okay. Thank you.
Thank you, Your Honor.
Thank you for being here. First, you need to solve the mystery. You're from up north. Does that mean Manitoba or does that mean Tennessee?
New Hampshire.
New Hampshire, the Granite State.
Yeah, exactly. My brother.
I need your name so the court.
I beg your pardon. My name is Christopher Tatum.
Thank you, Mr. Tatum.
I'm Daryl's uncle. I was a half brother of Daryl's father. He was a remarkable guy, and but started off very strongly, and then as Ms. Patel mentioned, he got into a downward spiral and ended up virtually homeless himself in his 50s. And he started another family with Daryl's mom, and he was in no position to be a father. And Daryl's mother was a lovely woman, but had real emotional problems as well, suffered from schizophrenia. So Daryl and his brother, and actually there is a third brother that didn't get any care at all in their youth. And when my brother passed away in, I believe it was 1991, Daryl was, I think, 7. So he really was stranded. So that's the background. And as Ms. Patel said, Daryl has issues as well. And all of which I would hope can be dealt with if he gets the proper care. I've been, in touch with Daryl and Kedrick more in the last 10 years. Daryl's other uncle, who was a half brother of mine, passed away about 4 years ago. So he was principally involved in trying to help the family. And so I've assumed that role in the last 4 years. I'm in a position to help them financially in any way they need. I do own a property here in Atlanta that I purchased very, very recently, and it was there was a period of time some months ago that I thought there was a chance that Daryl was going to be released into a medical program. And so I went ahead and bought a home where his brother is living currently. And it is a fixer-upper that Ms. Patel gave the strategy where they could both work on the home. His brother is very, very talented, as I'm sure Daryl is, if given the chance in construction. So the idea being they could renovate homes, live in the homes, renovate them. One thing I would say about Daryl is when he was 16 or thereabouts, he was virtually a scratch golfer. Is enormously talented. He is absolutely fixated on golf. And the hope I have is that when he does finally get out, that I can help provide a home and wherewithal, and hopefully we can find some employment for him or work, and then he's really his real love is golf, and then enable him to enjoy his life playing golf. So. Create as normal a life as possible for him. But I wanted to be here to tell you that I'm prepared to help them in any way I can.
Well, Christopher Tatum, Mr. Tatum, thank you for sharing that. That's some helpful background, and it sounds like you are a all too uncommon force for good in Daryl Tatum and his brother's life. They lacked that for many years. And we should all be grateful that you are trying to create some opportunities for both of them. Hopefully you understand that Daryl Tatum is going to be taking a little time away from either pursuing carpentry or golf or whatever in light of the situations that happened a couple years ago. This type of crime against the person is unfortunately all the rage right now in our community, and people are understandably real concerned. And so we need to strike the right balance between making sure we're getting Daryl Tatum heading in a direction where he can be cared for and getting the support he needs, but also there being consequences for some of the decisions that got Daryl Tatum to where he is. It would be fantastic if when Daryl is able to plug back into life here in Fulton County, that he could live with his brother at that place and do something. I don't know. It may be that it makes more sense for Daryl to be in New Hampshire or something, but that's something that family would need to decide at the appropriate time. But it is particularly significant that you are here and not in New Hampshire at this important moment in Daryl Tatum's life. So thank you for being here.
Thank you.
Mr. Tatum, Daryl Tatum, tell me what medications you take.
I take Prozac and that's it.
Just Prozac. Do you take that in the morning or at night or both?
I take it in the morning, sir.
Did you get it this morning?
Yes, sir.
Okay. When you take Prozac, does it make you sleepy or woozy or fuzzy, or does it help you focus?
It helps me with depression, and because they recommended an antipsychotic, and I've never.
You can just leave your mask where it is. You don't have to keep adjusting it.
I've took them in the past, and I didn't like the way they make me feel.
Okay. But the Prozac you take and it doesn't make you fuzzy.
No, I thought maybe the only medication that would probably be better would be something like for my health, like a Benadryl or something like that, because I felt like I was having problems sleeping.
Okay.
So I wanted to talk to the doctor about either like maybe taking some Seroquel or some Benadryl or something, because I mean, I'm not feeling good right now, to tell you the truth.
Okay. Are you feeling well enough that you understand what we're talking about?
I got aches and pains. I mean, I'm hurt a little bit.
Okay.
But I understand.
But in terms of understanding what we're talking about right now, you understand, for example, what your uncle just said.
Yes, sir.
Okay. And you are working on getting your GED?
Yes, I am.
And that's something you've been able to do while you've been at the county jail?
I haven't been able to do it at the county jail, but when I was locked up for probation violation, I took the pretest, I think 3 times, and passed it.
Okay. And that was in the state system? Where were you in custody for the probation violation? In Florida or Georgia?
No, it was the state of Georgia.
Okay. Mr. Tatum, you entered your guilty plea pursuant to Alford. Alford is shorthand for a U.S. Supreme Court case that allows a defendant to effectively tell the judge, I don't agree with everything the state said I did, but I'm going to admit to it anyway because I want to work my case out. Does that describe your situation?
Yes, sir.
Okay. You understand it's still a conviction. You saying Alford doesn't mean that this is a pretend situation. It's going to be a conviction for armed robbery and attempted armed robbery. You understand that?
Yes, sir.
Okay. Those were the things I needed to cover. Mr. Tatum, I find there is a factual basis for your plea. I understand you and your attorney may disagree with some of the things Ms. Hall shared, but it also sounds like if Ms. Hall took this case to trial, she would bring in 2 victims who would say, that's the guy who pulled a gun on me, and one guy even got shot by you, is what this person would say. And a jury could believe them. And if the jury believed those victims, you could be convicted at trial of a crime that's punishable by up to life in prison. And given your criminal history, that's probably what you'd get. So I do think there's a factual basis. I also find that your plea is knowing and voluntary. A knowing plea means that you've understood what we talked about. And if you didn't, you asked your lawyer or you asked me to explain. Do you have any questions about anything we've talked about?
No, sir.
You feel like you've understood what we talked about?
Yes, sir.
Okay, even though you're having some aches and pains?
Yes, sir.
Okay. A voluntary plea, we already talked about. That's the one where no one's forced you to do this. You're entering this plea. You may not be excited about it, but you think it's the right way to move forward. Is that correct?
Yes, sir.
Mr. Tatum, I'm sentencing you pursuant to the Probation Options Management Act. And that's a lot of words to say this little bit. When you're on probation, when you're done being in prison, when you're on probation, if you have a technical violation, you miss a meeting or maybe you disappear for a little while, you and probation will work that out. You don't have to come back in front of me. But if you catch new charges, whether it's for drugs or shoplifting or you're robbing someone, you're going to come back in front of me to deal with that. Okay?
Yes, sir.
All right. I'm going to follow the very carefully and thoroughly thought out negotiated resolution in this case. So pursuant to OCGA 1710 6.1E, it's a lot of numbers in one letter, but it allows me to go below the mandatory minimum when the prosecutor requests it. I'm going to sentence you on count 1 to 10 years to serve 5 years with the balance probated. Count 2 will be 5 years to serve. It will run concurrently with count 1. I believe Ms. Hall is correct that counts 3 and 4 merge. Count 3 merges into 1. Count 4 merges into 2. And that leaves only the obstruction count, count 7. And for that, I'll sentence you to 12 months to serve. That will run concurrently with count 1 as well. And so overall, your total sentence is 10 years to serve 5 years with a balance on probation. You'll get credit for all the time you've been in since you were arrested in this case. So you've done, it was up on the screen a minute ago, 500 days or something. It's you've been in custody 550 days more. So you've done a chunk of those 5 years already. I'm going to recommend to the Department of Corrections that they have you participate in a residential substance abuse treatment program so that you'd get drug treatment while in custody at the Department of Corrections, but I can only recommend it. I don't get to tell them what to do. They may consider that you get what's called integrated treatment, where maybe you're getting some treatment on the mental health side as well as on the addiction side, which is exactly what you would have gotten had you been in the behavioral health treatment court. But that did not come to pass for reasons I fully understand. You've got kind of a messy criminal history, and then you picked up these charges, which are pretty serious. While you're on probation, I will ask the Department of Community Supervision to assign you a mental health officer. That'll be someone who is more comfortable working with some of the things you're dealing with, talking to you about medication, et cetera. And it will be a special condition of your probation that you take any medication that a doctor has prescribed. So if you're working with a doctor who's saying take Prozac or Seroquel or whatever it is, you need to be taking that medication. And if you don't, that's going to be a problem because the medication is meant to help you be in a better space. Does that make sense?
Yes, sir.
You'll also need to stay off of Ponce de Leon Avenue. So I don't know where you're going to be hanging out, but you need to stay away from Ponce de Leon. That's where this bank was, where these things happened. Ms. Hall, did you have any other conditions of probation?
No, Your Honor.
Ms. Patel, anything else for Mr. Tatum?
No, Your Honor.
Ms. Hall may have asked this, I don't recall. We're working off a copy of the indictment. Do you have any objection to proceeding off a copy of the indictment?
No, Your Honor.
Mr. Tatum, normally I would have you sign the indictment, but we're not passing papers around right now. Do you authorize me to sign the indictment on your behalf, indicating that you've pled?
Yes, sir.
Ms. Patel?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
All right. Mr. Tatum, we'll get your sentencing paperwork entered shortly, and you should be on your way to the Department of Corrections. Well, I don't know, Ms. Patel, you may have a better sense of what that delay is, but you'll certainly go on the list of getting shipped out of the county jail and to the Department of Corrections soon. Okay?
Yes, sir.
Any questions?
No, sir.
All right. You say thank you to your uncle?
Thank you, Uncle Kit.
All right.
Your Honor,
Yes, ma'am.
can I give Mr. Tatum reporting instructions, please?
Sure. Do you do that even though it could be like 3 years from now?
Yes, I'll still have to have, give him reporting instructions. Yeah, we still.
Okay. So listen up, Mr. Tatum.
Are we streaming live? I was gonna ask for an address, but I don't want